All right, everyone, I'm going to call the docket. When I call the docket, you need to let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Desiree Castro. Thank you. Jan. Thank you. Madeira. Millie Reyes, custody. Jesus Navarro. Fatima Malara, custody. Oscar Lopez Jr. Paul Anthony Marino, custody. Marcus Anthony Freeman. Marcus Anthony Freeman. Kilo Kimmaker, custody. Ethan Castillo. Robert Luis Marino. Enrique Soriano. Jesus Navarro, is he in custody?
Yes, sir.
Thank you. Francisco Fidel de la Rosa. Sylvia Garcia, custody. Kimberly Cuevas. Thank you. Mark Anthony Freyer. Thank you. How do you pronounce your last name? Freyer. All right. Thank you. Wilma Ruiz Ortega, custody. Brandon Lee Villarreal. Felix Beltran, custody. Nicholas Vaquera. Nicholas Vaquera. Sebastian Gabriel Marino. He may or may not be by Zoom. We shall see. Zamara Irene Perales. Zamara Irene Perales. William Clark Gordon. Jorge Zuniga, custody. Ryan Jimenez. Thank you. Billy Joe Reynolds. Billy Joe Reynolds. Gary Hernandez. Rita Pineda. Rita Lisa Pineda. Jorge Zuniga, custody. Randy Gonzalez. Randy Gonzalez. James Kellogg, custody. Abel Gomez. Abel Gomez. Eugene Salazar, custody. Christopher Ray Martinez. Christopher Ray Martinez. Ruben Martinez, custody. Tiana Cheeseman. Mario Rodriguez, custody. David Cortez, custody. Israel Cortez, custody. Quentin Meadows. Quentin Meadows. Andre Xavier Crawford. Andre Xavier Crawford. Sienna Ray, custody. Christopher Mendez. Christopher Mendez. Jesus Santeo. Thank you. Okay, thank you. Luis Gomez, custody. Albert Gonter, custody. Alexis Hernandez. Thank you. Rita Lisa Pineda. Kenneth Howie. Kenneth Wayne Howie. Arianta Dela Cruz. Okay, thank you. Justin Guzman. Monisha Moore. Monisha Moore. Is there anyone who came in later? Your name was not called? What's your name? I'm sorry, what?
The motion to modify, Judge.
So what page is she on?
Email.
I just wanted to check in here first.
Oh, no problem. All right.
Votes on that. Okay.
Yes.
I didn't know if it was gonna get called here or down
Oh,
there.
no, that's okay. If you'll go down there, they'll take care of it.
Perfect.
All right, thank you. All right, attorneys, these are the rules of the court because I see some new attorneys here, so These are the rules. You follow these rules, the court can run smoothly. Number one, you're not ready to approach the court unless you confer with your client and confer with the state. If your client is in custody, yes, they need to be brought out. Once you confer with the state and confer with your client, just approach the clerk. She will have you sign in because we're going paperless. So in order for me to know that you're ready, you need to sign in. Do not talk behind the court reporter while we're on the record. You know we're on the record because I will have called the style of the case. Ms. Abrams, if you could raise your hand for the new attorneys. She's with probation. If your client is seeking probation, if there is an issue about their probation, please confer with her. She's an integral part of the system. Criminal Trial Division is here. Their files are there. Family Violence is here. Their files are there. Once you request an inmate from the deputy, do not leave the courtroom for security reasons. There are only a limited number of inmates that are allowed in at one time. If your client wishes to speak to the court in a language other than English, whether you speak their language or not, an interpreter needs to be called down. Please let the coordinator know, the clerk know that you need an interpreter. Once you requested an interpreter, do not leave the courtroom because there are a limited number of interpreters and they will usually arrive within 5 minutes. Today is Friday Eve. Let's keep it a great Friday Eve. I know we thought we were going to be retired. We're not. We're just going to have to get over the fact that we're not retired yet and look to the future. At some point, we're going to retire, right? So it's going to be a great day. Everyone, please confer. Yeah, we got a lot of static for some reason.
It's that same one.
Okay. Let's see, did you hear that?
After one.
No.
Yeah.
Herman, hello. It's always good to see you. That means that good things are going to happen.
Well,
Uh,
No, Judge, we signed it.
it's not a bad thing.
okay, awesome.
Okay.
I understand. It was like one.
Mark Rutledge.
That's me, Judge. I'm here, Your Honor.
Hi, I can't. Hi. You have a client on the docket.
Yes, Judge. There's two things we can do. We can do a plea today, ready to roll on it. Or I was looking up the requirements for failure to appear. The new legislative law that came into place has to do with he has to explain to the court about provide a reason why he didn't show up in court. I think that's all that's required. You can check with the prosecutor and see if that's correct. But he can do that, and then we could set a bond for him. He can get out. But that's kind of the two things that we need to do. I didn't want to set it for plea because it's an immigration problem. So I'd like him to talk to an immigration lawyer. But if we can get a bond set, I'd like that too. That'd be great too.
All right. Is there a reason you're not in court?
I don't have a car, Your Honor. I got in a car accident 2 days ago.
Okay. All right. So we're going to need you in court because your client needs an interpreter. That's number one. And two, your client says he hasn't had any contact with you.
Well, there's nothing really to talk about. Either we take a plea bargain or we get a bond set. That's all I've told him that we need to do. There's nothing more to do. He's accepted the plea offer. He just needs to talk to immigration lawyer, so we can get a bond set. But if we need an interpreter, we can set this for tomorrow, and I should get my car by then.
Now, what I'm going to do is I'm going to recall this for Monday, October 27th, and you'll need to be present in court.
Okay, I'll be there, Judge.
All right, thank you. Norma, call up an interpreter. You know, this reminds me when you would have like from Cooley High. It reminds me of the scratches on a record. Yes. And then you have to blow it off, and then you have to gently clean the needle, otherwise you'll damage the needle.
Correct.
William 540. Nicholas, get up.
Morning, Judge.
Good morning.
It was a good idea. I just wanted to make sure that that all the paperwork was in order. Jan Madura.
Yes, I had it all.
Wonderful.
Wilbur.
I think the defendant can be assumed.
No, she's here.
Oh, wonderful. Okay.
Mhm.
I haven't heard from Ms. Courtney now.
All right. Just 1 second.
Christopher Ray Martinez. Abel Gomez. Randy Gonzalez. Billy Joe Reynolds.
All right, who are you ready on?
It's 12 or 12 down. That's good. Ryan Jimenez.
5 minutes.
All right, yes. Yes. It is now. Thank you. It's gonna be a day, but it's gonna be a beautiful day.
It's fine. She's here, so. So we're ready whenever you guys are.
All right, Mr. Cortez. Cortez, come down. Good morning.
Morning, Your Honor.
Good morning.
Ready, Your Honor.
All right, Mr. Cortez, your attorney stated that he was in an accident, does not have a vehicle, but we're going to recall you for Monday, and your attorney will be here in person on Monday. Do you understand?
Okay,
Okay,
No, it's not okay. Do you understand?
see.
yes.
All right, thank you. We'll see you then. Thank you so much.
Thank you, Your Honor.
Anyone else ready?
Last one.
Oscar Lopez. Good morning.
Good morning, Robert.
All right, your attorney has informed us that they're in trial in Bandera County.
Yes, ma'am.
So we're going to recall this for Monday.
Okay.
Once you sign the reset form, you'll be excused. Thank you for dressing appropriately for court.
Yes, ma'am. Thank you.
You're welcome. All right, anyone else who is signed in?
Yes.
Okay. Marcus Anthony Freeman. Nicholas Vacara. All right, just have a seat.
Sorry.
Zamara Perales. Billy Joe Reynolds. Rita Panada. Randy Gonzalez. Abel Gomez. Christopher Ray Martinez. Quentin Meadows. Christopher Mendez. Kenneth Howie. I thought Kenneth Howie was in custody.
Yes.
Yes.
I'm gonna feel the thing.
There you are.
Thank
Thank
you.
you so much.
Have a great day.
Can I see the file on Kenneth Howie, please? All right, thank you.
No, mine's Paul. I don't remember, I'm going home with that.
All right, who's here for Jan Madera? All right, the court is calling 2024 CR 011624 State versus Jan Hawkins, AKA Jan Madera. Can I have parties announced?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Miss Madera?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madera, but that's her name, correct?
The case was originally submitted as Jan Hawkins. So
Okay,
it's-
but shouldn't Jan Hawkins be the AKA and not Jan Madera?
I think as long as they're both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madera?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count one. We're proceeding on a lesser included of count two
And what are you proceeding on?
on a class A theft.
No objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the, well, electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a class A misdemeanor? Range of punishment is anywhere, well, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant, by Berkshire Hathaway. It's reflected towards the bottom.
All right. Did you understand that to be the plea
Yes, Your Honor.
defense?
Your Honor, we understand that we can address the court on the, any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out all, we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here.
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may,
Mhm.
We've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea, on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose. Having us we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the Junior League.
Well, Judge, she doesn't have to stipulate to it. She's pleading no contest. And so that is the plea that's provided in order for people who disagree with
Mhm.
what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been with regards to the indictment that's a part of it where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why
least.
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this: if she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I would hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever, that's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence and the judge can look at that and decide that they find those documents credible and find that they are true or
I can't do any of that if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do
Oh,
not
y'all
stipulate
read-
to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
They're
thing,
third
I haven't
parties.
read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to, she's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
So yes, so everything needs to be reprinted and redone. Thank you.
Thank you.
All right, who's next? Anyone else ready? Brian Jimenez. Hello, good morning.
Just speaking with the prosecuting attorney, we are going to do pre-trial diversion.
Right, so your client needs to be up.
Yes, Your Honor, he's right here.
All right, Ms. Ferguson, I need a PTD, please. All right, you need to have all of the paperwork and everything filled out. Before November. All right.
Sure.
All right, once you sign the reset form, you're excused. Make sure you follow up on PTD, all right? All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, who's next? Kimberly Cuevas. All righty. All right, I need the plea paperwork for her. All right, are y'all still going to proceed with the plea?
We are, Your Honor.
All right. All right, the court is calling 2025 CR 008801 State versus Kimberly Cuevas. Could I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Jorge Canales in defense.
And are you Ms. Cuevas?
Yes, Judge.
All right, Ms. Cuevas. Where we left off, I believe on Tuesday, was I had gone over the plea bargain agreement with you. And according to the plea, there's a $1,500 fine. State is recommending deferred adjudication. They're taking in consideration 2025 PF 09696. There's an affirmative finding of family violence. There's to be no contact with Evelyn Reyna and Robert Reyna. Now, the sticking point for you was the affirmative finding of family violence. With an affirmative finding of family violence, you're not allowed to possess any weapons or ammunition. And with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent. Did you understand?
Yes. Judge.
All right. And so it was the court's understanding, we had this conversation. The court gave you time to speak with your civil attorney.
Yes, Judge.
Did you have time to speak with your civil attorney?
Yes, Judge.
And did you have time to speak with your defense attorney here?
Yes, Judge.
All right. So do you understand fully what an affirmative finding of family violence will mean? That's either yes or no.
Yes, Judge.
All right. And knowing that, do you understand that to be your plea in this court?
Yes, Judge. Can I just ask for the no contact order against Robert Reyna changed to non-injurious
No.
contact? Because we have
Because
children.
this is your plea bargain agreement. So what is in your plea bargain agreement is everything that's above the line. So according to the plea bargain agreement that you entered into, there's to be no contact with Evelyn Reyna and Robert Reyna. Did you understand that to be your plea?
Yes, Judge.
And defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
And knowing everything about the affirmative finding of family violence, knowing that the court, if the court follows your agreement, there's going to be no contact with Robert Reyna and Evelyn Reyna. Do you still wish to continue with the plea?
Yes, Judge.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it
Yes, Judge.
and sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be 200 hours of community service restitution. The BIPP, a TAP evaluation, follow all recommendations in parenting classes. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state offers into evidence, State's Exhibit 1 with all attachments. No objection, Your Honor.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge.
Did you understand by entering into this plea, the state would not be presenting any witnesses? Their witnesses would be in the form of just police reports. Did you understand that?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we'd ask the court to consider probating some of the fine and some of the community service hours due to the fact that the young children that she has to care for would take up some time.
All right. How old are your children?
I have a 6-week-old and a 3-year-old.
All right. And are you employed?
Stay-at-home mom.
So how are you supporting yourself?
I have savings from the beginning of the year, and then my parents are my biggest support system.
All right. So do you live with your parents?
No, I have my own place.
All right. So why did this happen?
There's always been history of domestic violence between my husband and I.
But I don't understand, how does the domestic violence between you and your husband result in an injury to a juvenile?
Well, I feel like he put her in the middle, but I have no,
What do you mean he put her in the middle?
during our altercation, she was in the passenger seat the whole time and he opened the door and was trying to shove our son into the car. So he put her in the middle and then I was upset. I don't have a good reason as why I went after her, but it was in the moment, I was really upset. So
All right, and how old is she?
at the time she was 12.
Excuse me, do you need a cough drop? You sure?
Yes.
Okay. All right, the court is going to sentence you to a $1,500 fine. That will be probated. The court will sentence you to 4 years deferred adjudication. Proof of employment within 60 days, no employment as a home health care provider or with minors. There's an affirmative finding of family violence. There's to be no contact with Evelyn Reyna and Robert Reyna. You'll need to find a third party for visitation. There's to be regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution. 100 of those hours will be deemed satisfied upon completion of parenting classes. The remaining 100 hours will be deemed satisfied once you complete BIPP. There's going to be field visits one time per month for 6 months. All right, was there any alcohol or drugs involved in this?
Just marijuana,
All right. When's the last time you used marijuana?
that day, March 13th, 2025.
So if you're drug tested today, is it going to be clean? All right. There's going to be a TAP evaluation, follow all results. I'm sorry, follow all recommendations.
Can I say something or?
Yes.
Sorry. I've already completed parenting classes.
All right, you'll need to provide that to probation.
Oh.
Okay. Is there anything else that's needed, probation? Is there anything else you need from the court to be successful?
No, thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, we can go off the record. So here's the thing. When children are involved, adults need to think with clear heads, right?
Yes, ma'am.
Because the 12-year-old doesn't need to be involved in this, right?
Yes.
Your younger children don't need to be involved in this as well. So I know there's a parenting app. That's what they're probably going to have you all use to communicate. And probation, if on the civil side, they want them to communicate through the parenting app, I will allow contact with the father of the children, but it has to be through the app. It's still not in person, okay?
Yes, ma'am. Thank you so much.
You're welcome. And there'll still be no contact with Evelyn, though.
Oh, that's perfectly fine.
Okay. All right, good luck to you.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome. Anyone else ready? Christopher Martinez.
Judge, I'm here for him.
All right, Deputy Laura, could one of you make the announcement for Christopher Ray Martinez, please? Hey, how's it going? All right, the court is calling 2025 CR 011500 State versus Christopher Ray Martinez. Can I have parties announced for the record for the state?
Todd Lessard for Mr. Martinez.
All right, this hearing was scheduled at 9 a.m. It is now 9:59 a.m. The defendant has not made an appearance. Deputy, did you make an announcement?
Yes, ma'am.
And,
Nothing else.
all right. Do you have any idea where your client is?
Judge, I don't. I wanted to point out to the court, this was an appointed case. It's a manufacturer delivery 1 to 4, which is the second degree. He's been indicted as a repeater, making it a first degree. I'm not qualified for first degrees on appointed cases.
All right, so we're gonna handle this first and then we'll handle the other matter.
Oh, okay.
So, yes,
We're gonna ask for a bond forfeiture and a judge's warrant, Your Honor.
court is gonna issue a judge's warrant, remand your client without bond, and counsel, you say you're not on the appointment list for this?
First degrees, yes.
Right, we'll have you removed then and we'll have someone else appointed.
Thank you, Judge.
Thank
May be
you.
excused.
Yes.
This is its file here. You have this other big one, see it?
Thanks for noting that, Judge.
All right, who's next? James Kellogg. Who's the attorney for Kellogg?
I am.
Hi. All right. So where are we on his cases?
Judge, we have 2 cases that are in discovery status this time, and we have an MTR, Your Honor. We're asking for a reset on all 3, asking for a contested on the MTR, and going to, I guess, set it for trial on the other 2, Judge.
All right, he has a motion to revoke.
Yes, sir.
All right, why don't I have the file on the motion to revoke? Okay,
I apologize. I may have not put the number on hold, Judge. Kellogg?
Ma'am, do you have a case? No, you cannot sit it there. Absolutely.
thank you. All right, state on Kellogg.
Yes, Judge.
We're gonna set this for a contested. Ms. Ferguson, if you can recall this back in 10 days for a contested hearing, please. All right, we're gonna bring you back for a contested hearing on November 3rd.
Thank you, Judge.
Thank you. Thank you.
I'll get it.
What do you want?
Okay. Okay. All right. All right, yes.
Page 5, third one down. Third, fourth, yeah, one set up.
Xiomara Paralis. Hi,
Good morning.
good morning.
Client is not here this morning. I'm appointed on this. I have not had any contact with
We'll
her.
pick it up.
Okay.
Court is calling 2025 CR 010467 and 2025 CR 010468. State versus Zamara Renee Paralis. Can I have parties announced for the record?
Megan Galloway for the state.
David McLean for the defense.
If y'all can make an announcement. All right, this hearing was scheduled at 9 a.m. It is now 10:06 a.m. Defendant has not made an appearance. Defense, have you had any contact with your client?
I have not, Judge. I've tried, but I have not been able to reach her at the information I was provided on my appointment.
Right. We will see if she answers to the announcement outside.
Thank you, Judge.
Deputy, did you make an announcement?
Yes, ma'am. No worries.
All right, state.
We're requesting a bond forfeiture, Your Honor.
All right.
Appreciate it, Your Honor.
All right, the court will issue a bond forfeiture, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor. Appreciate
You're
you.
welcome.
Excused?
Yes,
Thank you, Judge.
thank you. Have a good one. All right, who's ready?
Page 1.
All right, can I see the parties on Jan Madura? Oh, Ms. Madura, just give us a moment. You all have put on here that you're contesting the total amount owed for restitution. You're not, because you all agreed that she owed the amount to the junior league. Am I right? So
Right.
that's not contested.
Right.
So
Judge,
if
if
you
I
want to
may,
put that in there, you need to put specifically what you're contesting. If you're contesting the insurance company, then you should put the insurance company in there. Otherwise, you're saying you're contesting
Judge, may
your
I,
league.
may I address? it?
Sure.
Because I'm the one doing this, not
Okay.
Chandler, so. Judge, what we're contesting is just the final total amount that are in the the documents that are contained in State's Exhibit 1. And so that's what I'm trying to put on there, that we're contesting the total amount that they're saying is owed.
So you're contesting the amount that they're saying is
We're just
owed
saying
to
it's-
Berkshire Hathaway and Visa?
Yes, indirectly. I mean, in the documents, Judge, the State's Exhibit, it has that she owes, that the total amount for the funds that were taken were 11,000 something, okay? We agreed to make a payment of the 1,077.01 upfront, but we have never, and we don't want to in the paperwork to stipulate that the 11,000 number that's in the State's Exhibit documents is a correct number. We believe it's lower. So that's the only issue, and Judge, and the reason why I want to have this in the paperwork is because if we're requesting that you not order a restitution hearing and let the third parties handle that on the civil side, where they can get accountants and they can really dig into that. And so if we stipulate to the true and correct nature of all of the State's exhibits, that includes that 11,000 number, and on the civil side, then there's nothing for them to, have accountants come in and.
So this is what I'm telling you all. When you say you're not stipulating, you're stipulating to everything but the amount, you're including the amount to the junior league in that. If you want to put in there
Okay, I can.
something else to address that, you can put that in there. But when you all say you're not stipulating to any amount, then she's not even stipulating to the junior league amount.
Okay. We can put in there to owe to third parties.
Well, the junior league is a third party.
Well, the junior league is the complainant. They're not a third party.
What I'm telling you is the parties are the
State
state
of
and the
Texas.
defense.
Right.
Well, your client, the state and your client. The junior league technically is a third party. So whatever is in there that you all are not stipulating to, which it appears to the court from your plea bargain agreement, the only thing you're not stipulating to is the amount to Berkshire and the amount to Visa.
Yes, Your Honor.
Is that correct?
Yes.
So
And
why
that's
is
below
it,
the line anyway.
so why is it hard to put in there? We are not stipulating to any amount owed to Berkshire or Visa. Why can't that be added if that's the total amount?
I can do that, Judge.
Okay. Thank you.
Thanks, Judge.
Do you want us to print this out again, or can I just change the language?
You'll have to write it in there and then have her re-sworn by the clerk. All right. Anyone else ready? Paul Anthony Moreno,
Ready, Judge?
are there any applications in this case?
No, Judge, it should be a time served.
Thank you. Court is calling 2025 CR 0067778, State versus Paul Marino. Can I have the parties announce?
Lauren Espinoza for the state.
Jay Rich, Your Honor, for Mr. Marino.
And are you Mr. Marino?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Marino, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the drug-free zone enhancement language and proceed on the lesser included offense of possession of a controlled substance, PG1 less than 1 gram.
Any objection?
No objection, Your Honor.
Just one moment. All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading? I'm sorry, you already waived the reading of the indictment. There's a lot happening on my computer where screens are disappearing. All right, Mr. Marino, did you review the admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 1? Less than 1 gram as a state jail felony, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
No, Your Honor.
You're giving the
Oh,
right up to go
oh,
to
yeah.
trial and
Yes,
enter a plea.
yes, Your
All right,
Honor.
did you intend to give up those rights I've explained to you?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 29 days in the Bexar County Jail under 1244, and there's a $600 fine. Did you understand that to be the plea?
Yes, Your Honor.
Did you understand if you are seeking to enter into an agreement where your judgment is satisfied, the court can only sentence you to the 29 days if I follow your plea, whether or not you're receiving 2 for 1 or 3 for 1 at the jail. The court has no jurisdiction over that. Do you understand?
Yes, Your Honor.
All right. And defense is at the plea?
That's plea, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
It's up to you, guilty or no contest.
Which one do
You can, either one of them.
you want?
You know what you did.
All right, here's the thing. If you plead no contest, that just basically means you're not fighting the charges against you. You're not saying it's true. You're not saying it's not true. You're just not going to fight the charges against you.
All right.
Usually people will enter into no contest pleas because sometimes there are collateral consequences. For example, if you're charged with a criminal mischief, or if you're charged with a DWI or an offense that causes an accident, sometimes there are monetary amounts that are owed. For example, if there's a car accident, maybe that person is saying, because of this car accident, I suffer $6,000 in damages. If you plead guilty to that, they just take that over to the civil court, and the only issue for you to fight over that will be the amount of money. That's normally why people plead no contest. But what I can tell you, if there's no application for deferred adjudication, if you plead no contest and I find that the evidence is sufficient to find you guilty, I will find you guilty. The no contest plea is just something that can be used on the civil side against you. Do you understand?
Yes.
And a guilty plea is exactly what it says. If you enter a plea of guilty and if there are some civil penalties that are associated, they can go over to civil court and just take your guilty plea. You understand?
Yes, Your Honor.
So do you wish to plead guilty or no contest?
No contest.
All right, state any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objections.
All
Your
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. How long have you been using?
Like 3 years maybe.
All right. Do you have any family support?
Yes, before they had arrested me, I was staying with my mother, and I just talked to her a couple of days over the phone, and I told her if they let me out, would I be able to go back to the apartment? She told me yes, Your Honor.
And what were you doing living underneath the bridge then?
At that time, I was homeless and I didn't have a job, and after I had got locked up for that and I PR bonded out, I started working at temp services here and there, and my mom let me stay with her doing side jobs, you know.
So when's the last time you used?
Last time I used was the last time they arrested me recently.
And what have you been using?
What I have been, methamphetamine and marijuana.
All right. The court is going to find you guilty, sentence you to 29 days in the Bexar County Jail under 1244, give you credit for any time served. There's a $600 fine, time and money to run concurrent. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You have a drug problem,
Yes, Your Honor.
and just going to live with your mother, that's sort of like avoiding your problem. There are plenty of inpatient treatments that you can go to, which you probably need inpatient treatment.
Mhm.
Otherwise, what's going to end up happening is you're either going to end up back and forth in the jail or in the prison, or either your mom is going to have to identify your body. When you're released from jail, if you can't find a place for inpatient treatment, you come back here, I'll pick up the phone and find a place for you. Do you understand?
Yes, ma'am.
All right, good luck to you.
He has 29 days in custody, Judge.
Okay,
All
a
right.
total,
Yes,
then that'll be a judgment satisfied.
I verified that with the clerk here,
Okay,
then she can verify that.
all right, thank you.
Thank you.
Thank you, Your Honor.
You're welcome. All right, anyone else ready? Page 2, second one down, Mary Freeman. You're talking about Marcus Freeman? All right, Marcus Freeman?
Yes, I'm.
All right, and is he here?
Judge, we have not been able to contact.
All right, the court is calling 2025 CR 008, I'm sorry, 2025 CR 006852, State versus Marcus Anthony Freeman. Can I have parties announced for the record?
Melissa Albin for the state.
Orlando Castañon for defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:24 a.m. The defendant has not answered docket. Defense, have you had any contact?
We have not, Judge.
All right.
And we did reach out and try and contact him, but we've not been able to successfully do so.
All right, Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. He is not on there.
All right, state.
We're asking for a bond forfeiture in the judge's warrant, Your Honor.
All right, the court will issue a bond forfeiture, remand your client without bond. If your client makes an appearance, the court will reconsider. Thank you. All right, who's next?
Judge, may I quickly make an announcement? I
Yes.
just signed on, we were signed on Mr. Martinez, Christopher Ray Martinez. It's
Yes.
been discovered by the state that we know where his whereabouts are.
Oh, we do?
Judge, I believe he's in custody. It's showing that he was arrested for a third-degree felony
Okay,
yesterday.
so which page is he on?
Um,
I think that was the first or eighth page.
Let me see.
Christopher Ray Martinez.
All right, let me look up here. Because I don't have any of the cost number listed. Do we know the
it's
cost? number?
not on docket. It's 2025.
Just 1 second. 2025.
EF
Mhm.
42240.
Yes, you can. All right, Norma, on Christopher Ray Martinez. That's gonna be recalled for Monday. And, yeah. The judge's warrant will remain. His new case is an assault case. So on Christopher Ray Martinez, page 8, judge's warrant remain because he has a new assault case. And then we'll set it for Monday and I'll hear argument. No. All right, thank you. Are the students here from Harlingdale? All right, anyone else ready? Is there anyone who's signed in and is ready? Yes. Who do you have?
William Clark and Rita Pineda.
What is happening on William Clark?
It's our first setting, Your Honor.
All right, Mr. Clark, come forward. Let me find him on the docket. All right, it's William Clark Gordon.
Oh, yes.
All right.
Sorry, my mistake.
All right, State, were you able to tender an offer?
Yes, Your Honor.
All right.
Judge, it's our first setting. We would like a chance to review some discovery with my client while he's contemplating the offer. We ask for a reset for that purpose.
All right, just one moment. All right, this is coming back on October 30th. Once you sign the reset form, you will be excused. Thank you for addressing appropriately for court. And that's going to be your plea deadline date. All right, and counsel, the reason why it's a quick turnaround, it's a state jail felony.
Well, they're doing a repeater enhancement too.
Okay, all right, we'll see you back on October 30th.
Okay,
All right, just have a seat. They'll give you your reset form.
and also have Rita Pineda, Judge, but she did not appear today.
All right, just one moment. It's on page 5. Last one, William Clark. All right, could someone announce for Rita Lisa Pineda? Court is calling 2025 CR 010639, State versus Rita Lisa Pineda. Could I have parties announced for the record?
Lauren Espinoza for the state.
Ray Lopez for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:32 a.m. The defendant did not answer docket. Defense, have you had any contact with your client?
Not recently,
All right, shows for. Deputy, did you make an announcement? All right. State?
Your Honor, we would ask for a bond forfeiture at this time.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider. And also your client has a violation report, and it is stating that she's been released from custody, and they have tried to have her back in compliance, but they have no response as well. All right, thank you.
All right, thank you, Judge.
You're welcome. All right, let me see the Madura case again. All right, court is calling 2024 CR 011624, State versus Jan Madura. Could I have parties re-announce?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Maduro.
All right, and now you, Ms. Madura? Yes. All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, according to the plea, the state is waiving count one, proceeding on the lesser included offense of theft, $750 to $2,500 under count two. They're recommending deferred adjudication. There's restitution of $1,777.01 to the Junior League of San Antonio through the DA's office, and that has been paid. Is that
That's
correct?
correct, Your Honor.
Did you understand that to be the plea?
Yes, Your Honor.
State,
That's right, Your Honor.
defense.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be restitution of Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense under count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Well, for exhibit one with all attachments.
Any objection?
No objections, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state would not be calling witnesses? Their evidence would be in the form of witnesses' statements, police reports, and bank records. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right, with regards to the amount that's outside your agreement, we'll come back for a hearing. And at that time, I'll sentence.
Okay.
All right, Ms. Ferguson, I need a reset date. And this is just for restitution?
And Judge, are we gonna have a full restitution hearing? If so, we're going to have to get a forensic accountant, I'm not an accountant, to go through all of the documents and bank records to prepare for that hearing. Your Honor, I would respectfully request if you would not order restitution or not make a decision and not have a hearing and let them handle that on the civil side in the civil courts.
Yeah, I'm not gonna do that.
If I may respond briefly.
Yes.
Just the state's theory that that amount be assessed as restitution is that is an amount the defendant received the benefit of. She can't keep.
I'm sorry.
She can't keep that benefit.
Okay. All right, we'll set it for a restitution hearing. Norm, I need a reset date for a restitution hearing.
And Judge,
You
just to
have
make
45 days.
just to make it clear, we're not requesting that she keep anything. We are requesting that we get to the correct amount.
Okay. All right, we'll be back on December 11th. Once you sign the reset form, you're excused, and on that date, I will sentence. All right, thank you. You're welcome.
You need anything else from me, Judge?
No, that's all.
Y'all have a great day.
And would be excused, Your Honor?
Yes, once she signs the reset form. All right, who's next? Nicholas Vaquera? All right, why are we late?
Traffic.
All right, here's the thing, docket is at 9. You cannot be late for court. Do you understand?
Yes, I'm aware.
All right, and you filed a motion to remove GPS bond condition?
Yes, Your Honor, that is correct. We did file a motion. We would like to set that for a hearing. You don't.
You ready to proceed on a hearing?
Yeah, sure.
All right, the court is calling 2025 CR 009909 State versus Nicholas Vaquera. Can I have parties announced?
Rick Pena for the state of Texas.
Austin Hagy representing Mr. Vaquera.
Are you Mr. Vaquera?
Yes, ma'am.
All right, defense has filed a motion requesting the removal of GPS. State, are you opposed?
We are opposed, yes, Your Honor.
All right, defense, you may proceed.
Your Honor, the reason why we're filing this motion is my client's had the GPS on for well over a year. He's come to every court date. He has not had any issues with his GPS, with reporting, coming to court. We do apologize for him being a little tardy this morning, but he has come to many court dates and been on time. And for those reasons, we do ask that the GPS be removed. He has had no contact with the complaining witness. They do not have contact. They do not have a relationship of any kind. And for those reasons, he is also trying to work multiple jobs, and in coordinating with GPS, it is very hard for him to coordinate those different jobs. So for those reasons, we are asking to remove GPS or at least place them on tracking only while we continue to fight this case.
State would object to removal and tracking. State would ask that GPS conditions remain as they are. Given the nature of the charge, the facts as they are alleged up to this point, Your Honor, as well as some history with this defendant on this particular type of behavior, I I will say upfront that the history I'm about to provide to the court all did lead to us dismissing the cases. However, it's still worthy to note that in October 2016, he had a prior sexual assault of a child case that I can't seem to find the reason for the dismissal in, I guess, because of the age of the case in the system. But that charge came about, as well as a month later, another sexual assault of a child and an online solicitation of a minor charge that, again, for whatever reason, we dismissed it, and I cannot find the reason for such dismissal within the system. Because of that conduct and the history with the system, we would ask that GPS conditions remain as they are, Your Honor.
All right, defense.
Your Honor, there's been no violation while he's been on GPS, and just to have him in his current condition is just to extend punishment beforehand. Case has not yet been litigated. State is not ready to proceed at this moment. They're still waiting on a discovery matter. For those reasons, we are asking for at least tracking only. We would ask that it be removed. If he was committing violations, then this court would be aware of it, and we'd be addressing that violation right now. But he's been on GPS for over a year, and he's been complying with it. At this point, it's becoming punishment, and we're not yet at that point in this case.
All right, and what is the issue with discovery?
So when this offense occurred 2 years ago, police were unable to make contact with him initially until, as of recent, DNA was obtained from the complainant, but not him. Now that he's regularly appearing in court, I made the detective aware of that, and they did a warrant for his buccal swab that was just submitted to the lab on September the 30th. I called them yesterday. They hadn't got to it, but they put it at the top of the list, and I'm asking for a 30-day final discovery setting so we can get the results of that in. And they told me over the phone that 30 days should be more than enough time for them to finish testing of the defendant's buccal swab.
All right, Ms. Ferguson, I need a 30-day reset for discovery and state at that time you need to be prepared to tender an offer.
Yes, sir, we are.
Motion to remove the GPS is denied. All right, what date? All right, December 1st at that time. States you need to be prepared to tender an offer, and defense at that time if the discovery is not complete with regards to the buccal swab and the DNA. You can file your motion and the court will reconsider.
Thank you, Judge. I
You're
appreciate
welcome.
that.
All right, who's next?
Third one down, Hazel Dawn.
Abel Gomez.
Judge, I am here.
Oh,
I regret to inform you, Mr. Gomez is not.
it's always nice seeing you. All right, thank you.
And I was ready for trial too.
All right, the court is calling 2025 CR 010962 State versus Abel Gomez. Could I have parties announced for the record?
Lauren Espinoza for the state.
Robert Mount for defendant, we're extra special ready.
All right, this hearing was scheduled at 9 a.m. It is now 10:49 a.m. The defendant has not made an appearance. Deputy, did you make an announcement for Abel Gomez?
Yes, Your Honor, I did see it's not out there.
All right, defense, have you had any contact with your client?
No, Judge.
All right, state.
Your Honor, we would be asking for a bond forfeiture at this point.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
My phone's not working, so.
Have a good one.
You too, Judge. I'll see you later.
All right, bye-bye. All right, who else? Brandon Villarreal. All right, we'll wait for your attorney. Who's next? All right, who's here on Desiree Castro? If you'll come forward, please.
Yes, take care.
Probation, this is an application.
Oh, great.
Oh, no, it's kind of already.
Just one moment. Sorry about that. All right, the court is calling 2024 CR 011272, State versus Desiree Castro. Can I have parties announced for the record for the state?
State.
Luis Martinez on behalf of Ms. Castro.
And are you Ms. Castro?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I did, Judge.
Court will find that the state is in compliance with discovery. Ms. Castro, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, I did, Your
And
Honor.
did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving count 1 and proceeding on count 2. And regarding count 2, we are proceeding on the lesser included offense of kidnapping.
Any objection?
No objection, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
All right, the state is proceeding on the lesser included offense of kidnapping as a third-degree felony. Range of punishment, it is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, sentence you up to a $10,000 fine and up to 10 years in the prison.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I do.
Ms. Castro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry into the United States?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, the state is proceeding on count 2, and they're proceeding on the lesser included offense of kidnapping. There's a $2,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have been none.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Sophia with an F, Martinez, Isabel Pequeno, Carly with the C, ARLI, Green, Mariana Barnes with an ES, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count two, the lesser included offense of kidnapping, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
It offers states one in attachments.
And that's without objection, Judge.
All right, and state, have you spoken with the complainants?
Yes, Your
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
It's fine up there.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We're prepared to proceed to the judge.
All right, anything you wish to say on behalf of your client?
Judge, we asked the court to accept the plea bargain. We've done a lot of work with the state negotiations and then speaking with complainants and evaluating the cases. And the attempting to parse the responsibility of all the alleged co-actors or indicted co-actors. And so after all that work, we've come to this as a compromise agreement that we believe is fair to all the parties. We're asking the court to accept.
All right, and if you're drug tested today, what are the results going to be?
I'm sorry?
If you are drug tested today, what will your results be?
Queen.
All right, so do you want to do a drug test now?
I can, yes.
All right. Well, I'm going to send her for a drug test and we'll come back with sentencing.
Okay.
Can you, talk to Miss Abrams? She'll tell you where you need to go.
Yes, ma'am.
All right, thank you.
Judge, I've got another matter on another client on a bond condition.
Sure.
Yes.
Okay.
Yes. Just for family. Yeah.
All right, who's next?
8, 4, 5th one down, Brandon, yeah.
You had Alexis or non-list up there for the bond condition? Yeah, we have done that.
Right there.
Okay.
12 down.
Take care of a quick no objection.
All right,
I've got a copy of that motion if anyone wants to see it.
No objection from the state, Your Honor.
all right, just give me a moment. All right, the court is calling 2025 CR 08924 State versus Alexis Hernandez. Could I have parties announced for the record?
Rick Pena for the state of Texas.
Louis Martinez, on behalf of Mr. Hernandez.
And good morning, and you're Alexis Hernandez?
Yes, I'm correct.
All right, there's a motion to modify bond conditions. State, do you have any objections?
Not to the request to attend the Saturday.
All right, is there a time frame for this?
We don't just find time for this.
Yes, it's from 5 to 8, but I was wondering if I could have all the way to 10 PM just to like help the clean up and everything like that.
Sorry.
All right,
We need to go ahead and fill that out there.
yes, please.
So 5 to 10?
5 to 10?
It's not correct.
All right.
Thank you.
All right, the court will follow the agreement that's been reached between the state and the defense. You'll need to make sure that you are at home no later than 10:30.
Okay, thank you very much.
You're welcome.
We have this state sign off on that. That's what you want.
Yes.
Okay.
And what is the distance? Because if he's saying he wants to be there at 5 PM, then he'll need to leave before 5 PM.
I mean, 4:30 should be fine.
If you'll ask the state.
4:30.
Okay.
Should go on this one.
And y'all may want to, for GPS, you may want to put the address down.
Okay. What's the address?
5606.
All right, who else is ready?
4, 5th one down, Brandon, do you have it?
Brandon Villarreal.
Yes,
Good morning.
Ma'am.
Okay. All right, today is supposed to be the day for disposition.
We were here on Tuesday, Your Honor. I mistakenly thought that we were much closer to an agreement with the state than we are. We are not. So we would request a trial setting place.
I'm sorry, what?
We would request a trial setting place.
All right, so then your plea deadline date will have expired. Then this will be either a jury trial, or if you reach an agreement later, the court will not accept any agreement without good cause. Otherwise, you have to plead open to the court. Do you understand?
No, ma'am.
All right, do you want to discuss that with your attorney? Then we can come back.
Yes, please.
All right, thank you. Who's next? This one down, Mario Rodriguez. Mario Rodriguez.
Yes, Your Honor. Morning, Judge.
Good morning. How's it going?
Doing well.
Oh, we're so close to Friday.
Yes.
It's like- All right. Hello, sir. Hi, how's it going?
Good morning.
You always come in stealth, or either I'm reading and I'm focused on paperwork and I don't hear you. How's it going today?
It's going great, Judge.
Great.
It's going great. Thank you for asking.
Sure. Happy Friday Eve. Yeah. All right, so where are we on discovery?
We have the discovery. We also have an offer for applying for pretrial diversion. I'm gonna get with his attorney, Monica Galetto, so that she needs to explain it to him in a little more detail and fill out the form. We're gonna see if we can have one in Spanish. We're not able to do it today. He's accepting the offer, so we just need a little bit more time.
All right, could I have PTD setting, please? All right, well, we'll be back on December 2nd. Do you have any questions?
No.
All right, thank you.
Thank you, Judge.
All right, thank you. Who's the next person? Enrique Soriano? Oh, do you need me to sign anything?
Yes, Judge. I just haven't filled out the whole form.
Oh, no problem.
You believe that I was here.
Let me see.
I'm making you work extra.
Oh, it's fine. I can work on my penmanship. I used to get A's in penmanship and now, no.
Yeah. Okay, thank you so much. You have a blessed day.
And I'm sorry, what's your client's name?
Soriano. Ricky Soriano.
All right, thank you.
This is a discovery hearing, I believe.
All right, so where are we on discovery?
I've got most of it. I have to go to the district attorney's office to look at some of the videos and I just didn't get around to it, but we have an agreement. I'm gonna go tomorrow and look at this stuff. So if I can have about a week of this, it's all I need.
All right, Norma, if I can recall this for next week, please, date. All right, we'll be back on October 30th.
Okay.
And then the DWI, is that oh, that's the probation issue. All right, we'll see you back on October 30th. Thank you.
Maybe excuse.
Yes, it's final discovery. And are these the students from Harlingdale? Yay, what's your mascot? Okay, awesome. Come forward. Hello, hello.
Hi.
Hi. Hello, hello. Hi, so you're the teacher?
Yes, ma'am.
So what grade are you guys? Seniors? Oh my gosh, you're about to enter into the world of adulthood, which is so exciting, but nobody tell you with adulthood comes things that you don't want. Bills, you can't take naps, and you have to walk everywhere. Nobody's gonna pick you up and carry you. If I could go back to the time when I was a baby, I would take all the naps I could take So are you all going to go in the legal field?
I think besides three of us, yeah, most of us.
Oh, so what do you guys want to do?
Oh, for mechanic.
I'm sorry?
For diesel mechanic.
Oh, awesome.
I wanna pursue music. Be like a musical composer.
Oh, awesome. Yes.
Prosecutor.
Forensic pathologist.
But yay for the prosecutor too.
I think it did.
All right.
Trade school for electrical.
I'm sorry?
The trade school for electrical.
Oh, hey, a lot of money.
A defense attorney.
Yay.
Tattoo artist.
Tattoo artist? Oh, wow. Okay, that is so awesome. You know, I see Master Ink.
Or ink master.
Yes, Ink Master. There you go. And I'm always just amazed by the creativity to do that. But so state, where are you guys? We have two people who are interested in being prosecutor. Yes.
Raise your hands.
Yeah.
You? Oh, are you guys part of BCS Explorers right now?
Yes,
Okay,
sir.
that's awesome. So yeah, my name is Megan Galloway. I represent the state. I'm a second chair felony prosecutor. So basically what my job entails is receiving cases from law enforcement, evaluating them to make sure that everything is good and all laws were followed and that we have all the evidence, and then sharing the evidence with defense attorneys. And then we engage in plea negotiations to see if the defendant wants to take responsibility, or if they don't want to do that, then we have jury trials. And in this court, we're frequently in jury trials. So that is my job and I love it. Do you guys have any questions?
What school did you go to for law?
For law school, I went to SMU in Dallas. But my mom did graduate or she went to Harlandale High School. So go Indians. Yeah.
And then where are my defense attorney, Victoria Cruz? Hi, we have some explorers who, a couple want to be defense attorneys. Oh, you were? Hey.
Hey guys, my name is Victoria Cruz. I'm on the defense side. I went to Southside High School. I was part of the first Explorer unit there back in 2008. Anyway, it's a great job and I'm happy and I think you guys can do it as well. Good job.
So anyway, sometimes we'll have people who are in custody. That means that they did not make bond. So these are people who are in custody at the jail. They are in different categories. Usually the people who are in orange, those are male inmates. The people who are in blue are females. The females who are in yellow or yellow with stripes, those are females who are pregnant. That's to let the deputies know too, because they should not be handcuffed behind their backs. That's dangerous. The people who are wearing tan or white, usually those are trustees. Those are usually people who are designated as nonviolent, never tried to escape. And trustees are people who do different activities around the jail, maybe working in the cafeteria, serving food or doing cleanup. And sometimes they'll have them clean up around the jail. When I first started practicing law, inmates would actually come to the courthouse to do cleaning as well. Then you have those in red uniforms. Those in red uniforms usually signify gang affiliation, or either those are people who are charged with high-level offenses. And it's just really to let the deputies know so they'll know what kind of security is needed. Do you guys have any questions? So today is, oh, yes.
I feel like it's the, but why is it bad to handcuff like a person maybe behind?
Sorry. Oh, it's a medical reason.
Oh,
Yes. So it's not because the deputies decided, oh, it's not safe to handcuff pregnant women behind their back. Medical statistics and data shows that they're not supposed to be handcuffed behind their back. So the yellow will signify to them that they're pregnant, because sometimes you can't tell if somebody's pregnant or not, but usually they will check them at the jail if they're not visibly showing, to let the deputies know that they're pregnant. So that is why. Okay. So today is Thursday. And this is our Thursday docket. As you can see, we have a lot of people on the docket. We have a lot of people every day. This day, you have some people who are on probation, which means they have a contract with the court. They didn't go to prison, but they have different things that they need to complete while they're on probation to successfully complete their probation. Then we have some cases where people are here to get discovery, and discovery is just information that the defense attorney needs, defense attorney is supposed to have so they can adequately represent their clients. Because if you're just a defense attorney and you're coming to court and you don't have anything other than, oh, your client is charged with murder. Okay, what evidence do you have? So they get a chance to look at the evidence and go over it with their clients. And we do have probation here. Ms. Abrams? She left. Who else is here from probation? Hi, can you tell the explorers what you do?
And so what I do is I close for all the and I have all the CLOs with reading conditions off to that are on bond and that are going around where I need it and help to is there time and get them on their way to a very successful state.
Okay, and so we're going to take up some more cases, and then we will have Deputy Laura show you around. And we may have a deputy who can do that now. All right. So this is what well, before they go, let me just Mark Anthony Freya. Okay. And probation, this is an application. Who's the attorney?
He's on his way, just texting the judge.
So he's not here?
Yeah, he stepped out of the courtroom.
All right, just step back.
I'm sorry.
Yes.
Or
It is CTD. All right, Ethan J. Castillo.
Ready, Judge?
This is an application.
Yes.
I'm letting probation know. Court is calling 2025 CR 007447, State versus Ethan Castillo. Can I have parties announced for the record?
Warren Wolf for Mr. Castillo.
And are you Mr. Castillo?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Castillo, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented? Mr. Castillo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, thank you.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes,
Counsel, has your client been able to provide you with any defenses?
we've discussed that. There are no defenses.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Castillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, there's a $1,500 fine. State recommends deferred adjudication, and there's to be restitution for drug testing. Did you understand that to be the plea?
yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 120 hours of community service restitution, random UAs, DOEP, MRT, grief counseling, and obtain your GED. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty. Guilty.
State any evidence?
State offers into evidence states exhibit 1 with attachment as well as the discovery, well, that's the attachment, the discovery acknowledgement.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. What is happening with the credit card possession?
There were no cases filed on for that, Your Honor.
All right. Do you wish to proceed with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, if you notice in the recommendations I brought to the state's attention that Mr. Castillo lost his mother at age 40. She was 42 years old.
Okay.
And that was part of the reason why he was using illegal substances. And I asked the state to include a recommendation for grief counseling as infinite. He's 21 years old. And I think he would benefit from that in addition to the normal drug counseling because of the drug. You know, and I've already talked to him that that's not.
What is his criminal history?
I don't think he has it.
He doesn't have it.
And he's to finish his education. That's the reason I suggest to the state just to include GED.
Because of the credit cards that the court mentioned.
Okay. All right. Who's your support system? What do you, I mean, is he able to speak?
Yes.
All right. Do you have someone who provides support for you somewhere where you're going to be staying?
My brother.
And how old is your brother?
34.
All right. And where's your father?
My father is, he's nowhere to be found.
Okay. So who lives with your brother?
My cousin and my grandma.
Okay. So how long have you been using?
I don't even remember, like I stopped. Whenever, the last time I used was whenever I got in trouble.
All right, before that, how long had you been using? Or to what extent?
When did you start using? How old were you when you started?
I was like 20,
All right, and so how often were you using?
not every day, just like every twice a week.
Okay. All right. And when did you drop out of school? Or what grade?
I dropped out in 10th grade,
Why?
hanging with the wrong crowd and trying to be something I wasn't.
All right, so let me just tell you about wrong crowds. If I were talking to those other people, their parents would say that you're the wrong crowd. You understand?
Yes, ma'am.
So you drop out, and what did your mom say?
My mom was really upset with me, and I'm trying to make my mom proud.
Okay. And do you have any children?
No.
All right. All right, the court is going to sentence you to 3 years deferred adjudication. There's going to be regular random UAs, regular reporting by Zoom or in person. In custody, I'm going to ask for a referral to felony drug court. Felony drug court is a great program, and they'll be able to provide you the support system that you need to be successful.
Thank you.
All right.
Thank you, Your
So
Honor.
you're welcome. Just make sure that you're honest with them. So they'll be able to address any grief counseling that you need, any mental health issues, drug issues, all of that. And they'll be able to get you on the right track. As you can see, because I have so many cases, I won't be able to see you as intensively as they will be. They'll be able to see you every week to see how you're doing. Okay?
Yes, ma'am.
All right. So in custody, felony drug court, and a TAP evaluation, follow recommendations. Felony drug court should accept you if you're completely honest with them. There's going to be grief counseling. Probation, do you all have something for grief counseling? All right. And there's going to be 100 hours of community service restitution. I'm going to order that you obtain your GED. If you obtain your GED or either trade school certification, the community service hours will be deemed satisfied. There's going to be field visits 1 time per month until further notice. There's a $1,500 fine that will be probated. If you successfully complete this probation, you won't have to pay a fine. And there's to be restitution for drug testing. Counsel, if you deem the drug testing restitution is high, we can come back and have a discussion about it.
Thank you.
All right. Probation, is there anything else?
Then because of the GED, you're not gonna make home getting a job, right?
How old are you?
21.
We'll do employment, proof of employment within 45 days, no employment as a home health care provider or with minors, and then no unsupervised contact with minors. Anything else, probation?
No, that's.
Is there anything else you need from the court in order to be successful?
Nothing.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and won the win. Because in this court, my goal is to hopefully have people who are on probation who are rehabilitated. And let me just tell you what will happen. If you end up testing positive, probation is going to send me something. And then I'm going to have a compliance hearing where you come in and we're going to see if we can help you with that. But if you disappear, there's nothing anybody can do. You understand?
Yes, ma'am.
All right. And if you need something, just let probation know about it. If you feel they're not addressing it, you can always come back to court and address it with me, okay?
Okay.
All right. Good luck to you, okay?
Thank you, Ms. Wood.
You're welcome.
Thank you very much, sir.
You're welcome.
It's not, always the same. If you have family members out here, do not talk to them or you'll be asked to step outside.
All right, are the parties here on Mark Anthony Frey?
Yes, Your Honor.
Probation, this is an application. Court is calling 2025 CR 008985, State versus Mark Anthony Frey. Could I have parties announce?
Megan Galloway from State.
Joseph States in defense.
And are you Mr. Frey?
Yes, sir.
Counsel, you received all I'm sorry?
Prayer.
Prayer. Okay. I'm gonna remember it. No, if I don't get your name right, correct me, because I'm learning as well. All right, counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Mr. Freyer,
Yes, Your Honor.
did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true billing of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with driving while intoxicated with a child under 15. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Freyer, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, you could, if you're not a US citizen, you could be deported, denied naturalization and re-entry to the United States?
Sure.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's $1,000 fine probated. There's no application for deferred adjudication and the state recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours community service restitution, DWI, VIP live, DM.
DWI.
I'm sorry, the W.
It looked like an M. That's correct.
Yes. DWI intervention, ignition interlock for half the term, UAs and parenting classes. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead?
No contest.
State, any evidence?
State offer states one in attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor. May I interrupt you? May I look at the plea bargain page? Just one moment. I apologize.
Yes.
Sorry about that. I'm ready.
All right, anything you wish to say on behalf of your client?
Your Honor, my client regrets this. I had admonished him that if the child who was in the vehicle was with him who was injured, he'd be facing a different charge. And unfortunately, statistics are not in his favor for people who get DWIs. But if you would consider that he is from former military, I did discuss with him veteran treatment court. He actually asked me about that. And I advised him that this current offer that we have with the state, that the court could consider military service, that he's going to receive a probation offer if the judge follows the deal. And that I want the court to know that he's already engaged in VA services. He's on 2 medications that prevent him from drinking. It'll make him sick if he drinks. He won't drink. He's engaged in services with the VA. He's already doing counseling. He wants to finish probation successfully. He doesn't want to drink. He doesn't want to get another DWI.
And have you internalized this?
Yeah.
All right, because usually what ends up happening, people who drive when they're intoxicated, right? If they're in an accident, usually they're just fine. The people who are usually injured severely and maybe resulting in their death are passengers and other people they're hit. And this could have easily been your children in this, because when people get in an accident with semis, usually they don't make it.
He had injuries himself, which was unusual. His right arm.
Yes.
Right or left arm.
No, that's very unusual, because usually the intoxicated driver is just fine. And as you know, they always say, or at least what I learned in driving, I didn't go to driving school, but what my mom always told me, if you hit somebody from behind, you're at fault. None of this, they were going too slow, because you're supposed to have a specific distance between you and the person in front of you. And if they were to make a sudden stop, the distance between you and that person is supposed to be such that you could be able to stop too without hitting them. You understand?
Yes, Your Honor.
And so with regards to the hitting of the semi, is there insurance involved with that?
Judge, I spoke to the complainant on that, and he was not requesting restitution, so we're waiving it.
All right, thank you. All right.
Your Honor, he has 3 children. None of them are adults. They're fairly young. His wife is unemployed. He's the sole provider for his family. And with the obligations he has with the counseling services he has with the VA, I was hoping that maybe you could hold the community service hours in abeyance, that way that he can focus on treatments and not miss work. If you can consider
And what do
that.
you do for work?
I work at HVAC.
Okay. All right. This is what, and did he confer to see if Veterans Treatment Court would accept them, or they say no?
We did not start that based on the state's recommendation offered and the terms that they made.
Does he want that or no?
he inquired about veteran treatment courts. He's open to being screened.
All right, this is what the court is going to do. The court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's $1,000 fine that will be probated, regular reporting by Zoom or in person, regular random UAs, ignition interlock for half the term, 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be continued treatment with the VA, DWI, Victim Impact Panel Live, DWI intervention. And is there any request for a license suspension?
Yes, Judge, the 2 years, and I can run concurrent with any during staff.
All right, so there's to be 2-year license suspension.
I did admonish him that the 2-year driver's license suspension would be imposed.
All right, proof of employment within 45 days, no employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
Oh, you are.
Okay, and I'm sorry, probation, I'll do a referral to Veterans Treatment Court.
Yes, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Probation, I didn't recommend the TAP evaluation because he's already in treatment, but do y'all just want a TAP evaluation to get a baseline? All right, so we're gonna do a TAP evaluation, but they know that you're receiving treatment through the VA, so they'll let that continue, okay?
Yes, Your Honor.
All right, good luck to you.
Thank
You're
you.
welcome.
Thank you, Your Honor.
Yes.
Is this thing still in effect?
Yes. An evaluation for what? Thank you. All right, who's next?
Next, page 5, second one down.
Sebastian Marino. Hello. Hi, why were you late for court?
I was actually downstairs. This is the one that Judge, you told him to just go
Ah.
downstairs.
Okay, that's true. So where are we?
So Judge, the hang up was actually a restitution issue. The
Mhm.
state needs to find that before they can finalize everything. They didn't want to do a restitution of any, they wanted to get, and I believe no one's gotten a hold of them
Well,
just yet.
okay,
Sorry.
if I could, the intake attorney made an offer that I was unaware of, okay, and so it includes resolution on cases that needs to be relayed to the complainant, and nobody has ever reached out to the complainant. So that's the issue that I've addressed with that attorney that needs to be addressed by them since they made the offer.
Yes.
And then they need to also inquire if there's any restitution owed.
And we're understanding of that, Judge. According to state, it's gonna take about 2 weeks. We're fine with a 2-week recall.
Yes,
2 weeks or 3 weeks?
3, please.
All right, Ms. Ferguson, I need a 3-week reset. 3-week reset. All right, so we'll be back on November 13th.
Thank you.
All right, thank you.
Maybe excuse?
Yes.
Thank you.
All right, who's next?
Page 4, fourth one down.
Wilmer Ruiz Ortega. Yes. All right, state, were you able to tender an offer?
Judge, so no, and I will proffer to the court why, but regarding discovery, all discovery is complete in this case except for the firearms and GSR analysis. I did reach out to the lab yesterday and they confirmed with me that it's not yet been completed. And so we're waiting on that as far as discovery. Regarding the case, I have reviewed the evidence that we have and tendered to defense. However, I've been unable to make an offer on today because I've been unable to speak with the next of kin regarding the offer that I think is appropriate in this case. I do have a meeting scheduled with them. It was just a little hard to get a time in place because there's a next of kin because of the injuries in the case. And so I do have a meeting planned where I'm going to discuss that with them, and then I'll be prepared to tender an offer at the next setting.
All right, Ms. Ferguson, I need a date at the beginning of December. Is that enough time?
Yes, Your Honor.
All right, so we'll be back on December 2nd and hopefully the GSR will be in.
Yes, Judge.
All right, thank you.
Thank you.
You're welcome. Who's next? Albert Gunther. Thank you. Court is calling 2023 CR 6544 State versus Albert Carl Gunther. Could I have parties announced for the record?
Eric Baker for the defendant, Your Honor.
And are you Albert Carl Gunther?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Are you the same Albert Carl Gunther who was placed on deferred adjudication in 2023 CR 6544 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on October 13th, 2023 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Number 2, Your Honor, on or about the 30th day of September 2025 in Bexar County, Texas, the defendant Albert Carl Gunther did then and there illegally use a controlled substance, namely methamphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
True.
We'll waive the rest, Your Honor.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. I believe we are in agreement to extend Mr. Gunther's probation for 18 months and amended conditions so he can go to SATIF, followed by aftercare and the job readiness program.
All right.
That is correct, Judge, and Mr. Gunther has noted number one, he is struggling with his drug addiction and he's willing to go to SATIF. He did complete outpatient intensive successfully, but it didn't really stick like he wanted it to. So he's a willing participant and wants the help for SATIF.
All right, so other than outpatient treatment, has he completed anything on probation?
We did the TAP evaluation.
Any objections to the court reviewing the court summary?
No, Your Honor.
May I approach him?
Yes, thank you.
Your Honor, this is his first MPR.
Okay. State, do you know what is his criminal history?
Give me 1 second, Your Honor. I will.
This is the only felony. He does have a direction of the highway many years ago.
I'm sorry, and what would that be?
Direction of a highway rose out of a DWI.
Okay.
Yes, Your Honor, he's only got the obstruction and it looks like a UCW from April of 2023. And I'm trying to see what happened with that. Right.
Mike tells me it was along with this case here.
It was TIC'd, I believe, on this same day he was placed on probation for this case.
All right, Mr. Gunther, I'm going to give you a choice. These are your only choices. There are no other choices. 1, I can revoke you and I'll sentence you to 3 years in the prison. Or 2, you'll remain in custody. I will have a referral done for you for felony drug court. If felony drug court doesn't accept you, you're going to be going to SATIF. And you will be extended for 2 years. So which do you prefer?
Option 2.
All right, then the court will deny alternate amend conditions to include a referral to felony drug court. If not accepted into felony drug court, then he'll be going to SATIF and extend for 2 years. Probation, is there anything else? And I'm so sorry, probation, there's going to be field visits upon release until further notice. Do you have any children?
No.
Okay. All right. Thank you.
Thank you, Judge.
Thank you. Good luck, okay?
Thank you.
Have a seat, sir.
Okay, who's next?
8-6, first one down. Very good one.
Gary Hernandez. Hi, council.
Good morning,
Good
Judge.
morning. So on this case, where are we on discovery?
I believe that the state's provided all the discovery in this case at this point. They
And-
haven't been able to locate their file this morning.
Okay.
We, however, conferred, I've offered mitigation on behalf of my client. The prosecutor is going to email me a proposed offer.
Okay. All right, when would you like this recalled, counsel?
Judge, whatever is convenient to the court.
Oh, no, just let me know.
In a month.
All right, Ms. Ferguson, if I could have this recalled in 30 days for plea deadline date, please. All right, we'll be back on December 2nd. And counsel, there's a motion to suppress that you filed. At that time, if you'll let the court know whether or not it's dispositive.
Yes, sir.
All right, is there anything else?
That is all.
All right. And counsel, if you would speak. Thank you.
Thank you,
Good
Judge.
seeing you.
Good seeing you
Thank
too.
Thank you for dressing appropriately for court. All right, Steak, I'm sorry, Yaya, anybody else? Went down, Ariana to the recruit. Arianta Dela Cruz,
Point, Your Honor, I believe he is on Zoom.
is she the one who's listed under iPad?
It's a he.
Okay. Are you Dela Cruz? You want to call your client?
I did call and the number says this number is no longer in service.
All right, because.
Hello? This is set for
Just
rest.
1 second.
Okay, sorry.
All right, if you'll start your video, please.
There he is.
All right, so sir.
Hello?
You need to move the durag.
I'm sorry. You said, is this for Dela? My name is in Dela Cruz, though. Sorry.
I know we're trying to get our waves, but that's only an overnight thing. You can't do the waves in the morning for court.
Sorry.
All right, so we're here for, and are you Dela Cruz? Just give me a thumbs up if you're Dela Cruz.
No.
He's not Dela Cruz. So
It's
you're
not
fine.
Ariante?
No.
No.
Yeah, they told me he was on Zoom. But Judge, I can.
Wait, just one second. Are you able to type? Can you put your name in the chat, please? Quentin Meadows. All right, Mr. Meadows. I'm going to put you in the breakout room. We're waiting for your attorney.
Okay.
Your client is supposed to be here, either by Zoom or in person.
Correct, Judge. The issue is restitution.
Can't take it up until your client is here.
They are waiving restitution if that
Can't
matters.
take it up until your client is here because I gave him a choice of Zoom or in person. So if you can get him on Zoom, we'll take it up, okay?
Do my best. Judge.
All right, thank you. Who's next? Hi.
Judge, why is he wearing two watches? No, I'm trying. No.
Yeah.
Alex, Judge, we, oh,
Felix Beltran.
we have an agreement, Judge, Mr. Moreno, the gentleman in the wheelchair, but we'd like to do it tomorrow, I think.
Just give me a second. All right, when is this coming back for trial?
I haven't spoke to Mr. Martinez, but the 3 dates that I proposed would be either a November tenth or the January 10th date or February.
All right, Ms. Ferguson, put this down for a jury trial date, November 10th, please. All right, thank you.
I was gonna pick that date, so.
Oh, look at me, I'm reading minds today. All right, everyone, court is going on recess. Where's Yolanda?